in a pending criminal case, my lord. It was to be listed after 4 weeks, but now it is nearly 2 months, my lord. It is not listed, my lord. Can it be on 5th, my lord? 4th is holiday.
Let it be on 6th, because on 5th there are many cases. Let it be on 6th, you make a mention in the morning. Some of your junior
Okay.
may make a mention
So this I will give
on 6th.
6.
Yes,
Well, this is a criminal petition, my lord. It was last listed on 23rd of January, my lord, of 23. They have been not listed. So my pay it may come on 9, my lord. Okay. 9.
11th, 9th, the board is full. That's why to come for orders.
My lord.
May I please, Lord? I beg to mention for a motion matter criminal petition, the date is fixed on before the Learned Court on 5th. May I pray for list the matter on 5th?
When the order was passed,
Lordship, on 9th of this month. The POCSO
9th
matter.
of August. Why you have filed it last moment? Not possible on 5th,
To 5th is a day.
on 6th.
May I please, Your Lordship?
Obliged.
My lord, item number
Did
26.
you file or yet to be filed?
Already filed.
You have the number
Yes, sir.
My lord, item number 26, my lord, please.
36.
26, my lord.
Ah.
This matter has been listed as per my request, my lord. My lord, in the morning, because of illness of my daughter, my lord, I have to leave the court, my lord, for taking her to the hospital, my lord. The matter will be taken after 1 week, my lord.
On the priority council for the matter. Okay.
May it please, Your Lordship, with the consent from the other side, I beg to mention item number 45. 45,
Yes,
supplementary. Lordship, can be taken up on 18th of September.
the prayer of council.
Yes, may I please, Lordship, there's one matter criminal appeal. Can it be come on, already last occasion came on 1st of August. Not least, Lordship, can it be come on Thursday, Lordship, on 5th?
Not on Thursday, we have many cases. Try on 6th,
6th,
or if not on 6th, sometimes on 11th.
11th.
May it please, Your Lordship, with the consent of the other side, I beg to mention item 27 of today's list. Lordship, my senior is out of town. Can it be adjourned for the day? Can it be fixed after 2 weeks?
20,
7, Lordship.
these are order matters, right?
Lordship. I'm for the respondent number 2.
Just wait for a few minutes, we'll pass the order.
I'm praying for listing on tomorrow or day after tomorrow.
Why? All these days, what you've been doing?
In this case,
pros part of the AQ is closed by the learned code below. That's why there is some urgency, my lord.
On 9th, we inform the court.
Learned trial got fixed on 5th, my lord.
Doesn't matter. You are approaching the court belatedly and you can want the matter to be listed hurriedly. Cannot be done. There are other matters waiting in the queue.
My lord, I have another prayer for listing another criminal petition on any date, my lord.
On 9th itself.
May I please, your lordship?
Most
Lordship, I beg to mention for a listing of criminal petition, lordship. Can it be fixed on 10th of September, lordship?
When it was last listed,
Last is 25/6/24.
what was the order passed?
Lordship, honorable court has called for the lower court record, lordship, but it was not received yet.
On 11th for order.
Obliged, lordship.
With your lordship, praying for the listing of one IA criminal 777 of 24, Guljaruddin and other Bata state of Assam on next week.
For what? Why
Suspension of-
are you making this mention? Why this I to be listed?
It's already actually last date of posting was 2/8/24, suspension of sentences,
When it was last listed,
2/8/24.
what was the order passed?
Lordship,
Not aware. On 13th,
Lordship, I have another one prayer, same suspension of sentences, Rubina Khatun and another Bata state.
on
of Assam.
13th,
Another date, any other date, 14 or 12. What I'm saying,
14th is Saturday,
12 it means.
12th is Thursday. In that case, 16th. Up to
12.
you.
Short date in front of.
Try your luck on 11th. Yes.
Lordship, I beg to mention item number 6, criminal revision petition. In this case, lordship, Elshore was called for, but Elshore not received, my lord.
Wait for your turn.
Yes, my lord.
Ask someone to be here.
Wait, your lordship. The listing of criminal petition lordship, for orders, lordship. Next date in the lower court is on 10th, lordship, 10th of this month.
9th.
May I please, your lordship? I beg to mention item number 17. In this case, my lord, we are required to file an implement petition. There is a new incumbent, lordship, incumbent retired. So we contact with our client, my lord, but could not contact. So I pray for 2 weeks' time.
Let the matter reach. We'll pass the order.
File your lordship.
May I please, your lordship? Lordship, I beg to mention for listing criminal petition 421 for order.
When it was last listed. Why it should be listed for orders? What is the reason? What is the urgency in the matter?
Urgent.
What is the urgency? On 13th,
May I please, your lordship? Lordship, prayer for listing criminal revision petition, lordship, and earlier was left over on 14/8/2024. So lordship, can lordship,
on 13th,
short date, lordship, and otherwise
short date you want 9th,
published.
My lord, in this case, I'm appearing for one of the respondents, item 7,
Eight.
item 8. And the matter since 2023 has been pending before the Honorable Court for taking steps. And on 2 occasions, matter came up before the Lozama Court, ordered for taking steps. Steps were not taken. And it was before, on one time also, it was before the court also.
why it has come before this court?
I mentioned Milord because since 2022, 21 Milord matter is pending. There is a stay order.
This is,
I have filed an application for vacating this stay also. It is appointment was challenged, Milord. Under the
actually, huh?
bench 2 matter.
You are appearing for,
That's number 8. Against the appointment of Edmonds and 2 teachers belong in the school under the 17 Act that were challenged. And otherwise also, this application is not maintainable here because petitioner, if he agreed, has to file appeal before the state government against the decision of the state level committee. Before the laws of
Saliha,
court
we'll
also,
we'll take it up at 2 o'clock. Our first item, the petitioner is not here. And
before the Lozama court also, she was never present.
we pass the order at 2 o'clock. Let the petitioner be here. If doesn't appear, we'll pass the appropriate order.
Mind.
Verma. There is a provision of an appeal.
Yes, sir.
Did you prefer any appeal?
No. My lord, in this case, what happened, my lord?
Hmm?
The objection filed by the private respondent. His stand is that you are provincialized as headmaster computer.
Likha. Or Mr. Taylor Scott, counsel appearing for the petition. And Mr.
G. Pegu.
Lawrence. Standing Counsel, Department of School Education, for the respondent numbers 1 to 4 and 6. Any government advocate here?
Government was not made part.
No, Pegu.
No, sir.
Right. Government advocate Assam for the respondent number 5.
Party.
My lord, 5 and 6. This is
The petitioner.
Post this with the product.
It is the contention of the petitioner that since 1901-1988, he served at, as an assistant teacher, served as an assistant teacher in Vidyapur Anchalik ME Madrasa in the under the Bongaigaon Education Block of District Bongaigaon. Since its ad hoc state, since consisted on being recommended by the school managing committee and being appointed by the head teacher of the said school. However, while provincializing the services of the teachers of the said school under the provision of the Assam Education Limited provincialization of services of teachers and reorganization of education institutions bracket 2017. Disregarding her seniority, the respondent authority provincialized the services of the respondent number 7 and 2 others. Though she is senior to the respondent number 7. Pursuant to the order of the court, Mr. Pegu, Learned Counsel, sending to the Department of School Education, place the order of provincialization of the respondent number 7 and 2 others, namely Baharul Islam and Gyasuddin Sarkar, assistant teacher of said school on Antoparadiga, Vidyapur Anchalik ME Madrasa, now ME school. Under the Deputy Inspector of Schools, Bongaigaon, as tutors under the said 2017 Act. From the appointment orders of the respondent number 7 and 2 others appointed as tutors by the Director of Elementary Education Assam on 05022021, placed before the court, it can be seen that the District Scrutiny Committee, following the provisions of the 2017 Act, recommended their names for provincialization. And thereafter, the state level committee scrutiny committee considered provincialization of them, and their approval, the Director of Elementary Education issued their appointments as tutors on 050220. The claim of the petitioner is that she is the senior most arts teacher in the said Vidyapur Anchalik MA school. And the state authorities should have considered or above the response number 7, considering the fact that she joined her service in the state MA Vidyapur Anchalik MA School on 1988, whereas the response number joined his service on 05/03/1988, and both used to teach art subject in the same MA school. Petitioner submitted that following the provisions of section 2 3 Roman 11 of 2017 Act section 3 within bracket Roman 11 of the 2017 Act and as there are less than 100 number of students at the said Vidyapur MA school, only 3 teachers have been appointed as tutors under the 2017 Act in the said school, one of which is to teach science and math. One language and one social studies. And as the petitioner was serving as a language teacher, her service should have been considered for appointment as tutor in place of the responsible. The response number 7 has filed an affidavit stating that he is a graduate, whereas the response number whereas the petitioner is only HSSLC passed 10 plus 2 plus. And that he was serving as the headmaster of the said school. Being a graduate. Therefore, the respondent authorities consider him for appointment as tutor by order dated Section 14 of the said 2017 Act relates to appellate authority, wherein it is provided that section 14 to correct. It is seen that the service of the respondent number 7 has been considered for appointment as a tutor on the recommendation of the district scrutiny committee, Bongaigaon. And thereafter on being approved by the state level scrutiny committee. However, the petitioner, instead of approaching the statutory forum, the state level scrutiny committee, by preferring an appeal to the statutory forum, by preferring an appeal before the state level scrutiny committee, have filed this. As the petitioner has an appropriate statutory forum for redressal of our grievances with regard to the appointment of the respondent number 7 as the tutor in said Vidyapur ME school by order of the judge is regarding her claim or such appointment. The court accordingly disposed of this writ petition, directing the petitioner to prefer an appeal before the state level scrutiny committee at the earliest on or before 28th of September. The level scrutiny committee represented by the Director of Elementary Education, Chairman of the committee, along with a certified copy of this. In the event of filing any such appeal before the director, come chairman of the directors, Elementary Education Assembly, come chairman. Nowadays, it is the director. As per the act, it is the director or the said authority shall dispose of the appeal of the petition in accordance with law, given an opportunity of hearing to the petitioner as well as the respondent number 7 for placing their relevant interest. And also on perusal of the records in original with regard to the appointment of the petitioner, which appears the respondent number 7. In order that shall be placed by the Deputy Inspector of Long Island. The appointment of the respondent number 7, the tutor in Vidyapur ME school, and attached with Noldova Lower Primary School pursuant to the order dated 0502-2021 under number EPT-16.PROVNP capital -UP within bracket Act 2017 bracket 2021-885 shall be subject to the outcome of said appeal to be preferred by the petitioner on or before 2009. We have this petition stands for.
My lord, the appeal may be disposed within a stipulated period of time. The appeal which is going to be filed by the petitioner may be disposed of within a stipulated period of time. That
Needless to say, in the event of filing such appeal by the petitioner on or before 2009, the same shall be disposed of by the chairman of the specific director in Assam, preferably within a period of 4 months from the preferably 4
Obliged.
This matter relates to Jimma of two mobile phones, Lordship. In fact, on the last occasion, they had given me a report saying that they were waiting for FSL report. And a few days back, I asked him about the FSL report, whether they have received it. They said they have not received. Today, of course, yesterday or I did not ask them. I can ask it today and Lordship can take it up at 2.
No, let the FSL report come, Mr. Sikka.
Lordship. Otherwise,
If the concern IO have not issued any reminder, ask them to issue reminder.
Lordship.
Not in it. We'll have it on 38, 30.
30. Lordship.
13th
But-
September.
30 September.
30. Wait, I'm going to be sick.
Ms. Jahan, ask the IO to do that
Huh.
and get that statement.
Yes, I'll tell them to issue a reminder.
If it is pending with the FSL authorities, at least we cannot give you Zimma at this stage, only after the,
The mobiles are there in the FSL office. So
that's
they-
what.
That.
Only after completion of the investigation
Yes.
by the FSL, we can consider, otherwise no.
30th of
Yes.
September.
September
30.
30.
Lordship.
Yes, Mr. Tiwari.
It's my lord for quashing of the FIR, my lord, and the charge sheet, my lord. How is that page 27, my lord? The type copy, my lord. Now, my lord, the petitioner before the lordship is the wife of the son of the informant and the wife of the grandson of the informant. Santosh Sharma and Meenakshi Sharma, my lord. Page 27 is the FIR, my lord. The type copy of the FIR, my lord. May I read, my lord?
Just a minute.
Two 94, 290.
Let's 323, 354, 34. Market. Yes.
My lord, the FIR is at page 27. My lord has already seen the FIR, my lord. Now, my lord, I'll immediately take your lordship to the affidavit, my lord, which I filed, my lord, only to show one judgment, my lord, which is recently passed between the same parties, my lord, by the learned Chief Judicial Magistrate, my lord.
I'll just show the story and how the people have been doing and how they have been proceeding, my lord. The, my lord, additional affidavit filed on, my lord, 29th of July 2024, my lord.
Yes.
It's, my lord, the judgment starts from page, my lord, 182, my lord. This is the judgment, my lord, which was delivered on 18/5/2024. Now, my lord, the judgment starts from page 184, my lord. My lord, the case of the prosecution in brief is that on 27/6/2024, the complainant, namely Sri Anil Kumar Sharma, lodged an FIR in the Balumul Police Station stating inter alia that on 2/6/2021, one Sri Krishna Vesha engaged by Sri Arvind Kumar Bhatrao, Uma Place, second floor, Adgaon. So, my lord, the judgment itself says that we are only residing in second floor, my lord. Even my mother is not at all residing in second floor, my lord. She is residing in the first floor. Only to, my lord, thereafter I'll show. Then last line, my last line on the judgment, my lord, last line above. Sri Krishna Vesha went to their second floor residence. So, my lord, only one residence is there in the second floor, which these accused persons are only staying, my lord, only to make out a case. My lord, may I read the entire judgment? Then, my lord, the entire case will be clear, my lord, if I read out. Or, my lord, may I show only the specific paragraphs, my lord, of the judgment to show how they have been filing, my lord. If my lord turns to page 186, my lord, for a moment, my lord, in the cross-examination, my lord.
Just a minute. What is this? Very respect. Yes, which are the 11 paragraphs you want to play?
My lord, at page 186, my lord, cross-examination of the informant, my lord, the brother, my lord, Anil Kumar Sharma, page 106, my lord, the second para, my lord, in cross-examination, PW1 stated that he has not stated in the FIR that the same was filed as per the version of his mother and wife. He denied the defense suggestion that he has not stated before the IO that the accused person has spit on his mother. Now, this is important. There are around 45 cases pending between him and his brother in the courts. And it relates to the same property where they presently reside. Out of the same, he has filed only one case for issuance of letter of admission, while the accused has filed the remaining 44 cases. My lord, these 44 cases are, my lord, this building is also a market, my lord, in the name of Uma Palace, my lord. There are lots of tenants, my lord. After the death of my father, my lord, the father-in-law of these petitioners, my lord, my younger brother was not sharing the rent, my lord. So, my lord, we started filing the civil suits in the court for distribution of the rent between this informant, the two sons and the two daughters. And wherein, my lord, now the civil court has in all the cases, my lord, has appointed receiver, my lord, and my brother, learned colleague, is appearing in all the civil suits, my lord. In all the civil suit, the receiver is taking the monies and is distributing among all the legal heirs of the, my lord, informant. Now, my lord, this is first I have shown. Now, he has only stated one case, but in all the cases, my lord, on oath I am saying, in all the cases, now, my lord, the receiver is appointed, he is distributing the rents. Now, my lord, would kindly turn to page 187, my lord. The third line, my lord. The accused has also filed some criminal cases against him. The principal dispute between them relates to property. Now, my lord, now the PW2 is the sister of, as my sister-in-law of these informants, my lord. In the last above 3 lines, my lord, when their brothers Anil rushed from the ground floor and hearing the commotion, the accused persons went away. Now, my lord, I'll just show relevant paragraphs only. Now, 188, my lord, in the cross-examination, this sister says that 188, my lord. My lord, first paragraph above 6th line, my lord. The building and market was started and initially built by their father. The same was developed and completed later on by my brother Anil Sharma.
Just a minute.
My lord, para 8, PW3, Sangeeta Sharma. This is the wife of the younger daughter-in-law of the informant, my lord. In para number, just 3rd line from the top, my lord. The incident took place on 26/2021, and the accused and they share separate apartments. Now, page 189, my lord, in her cross, my lord. Kindly see 3rd line, my lord. Since the pendency of the civil cases, both her husbands are not in talking terms. Her mother-in-law and her sister-in-law, whenever she comes, all stay with them. Now, last line of 189, my lord. Later on, she says that it is a possibility that the quarrel between, next page, my lord, the two sides may be due to the property dispute. Now, my lord, para 9, page 119. This is the investigation officer Nilima Boro, who did the investigation in this case. My lord, kindly see her cross-examination in the 3rd para of this case, my lord. PW4 stated that she has recorded a statement of witness Ambika. She did not state before her that the accused person has spit on her mother. She also did not state before her accused showed sandal towards his mother. She did not state before her regarding switching off the motor by itself. She did not state before her that the accused has threatened her on or the mother She also did not state that accused or accused wives or accused sons or accused daughter-in-law abused her mother or Sangeeta. Now, my lord, next page, my lord. 191. That the accused person did not assault or molest her. She also recorded a statement on informant Anil Sharma. He did not state before her that the accused spit on his mother. Thereafter, he also did not state before that the day of incident he went to the terrace. He also did not state before her that the accused person showed sandal to his mother. But these are everything, my lord, she has stated. Now, my lord, the important paragraphs I'll just show, my lord, why I have preferred this criminal washing, my lord. Page 196, my lord. This is what the learned CGM has also recorded in the judgment, my lord. Page 196, para 17.3, my lord. Furthermore, there is an admitted animosity between PW1 and accused person due to property dispute between the parties. It is also admitted by PW1 that there are around 45 cases pending between him and his brother in the courts, and it relates to the same property where they presently reside. Thus, in the face of such animosity, there is a possibility that PW1, 2, 3, these are some of the PWs are here, once have proposed 161 statement in the present case, which I have filed before the, in order to see the accused person being punished.
Yes.
Now, my lord, I'll just come to the, my lord, now I'll come to the main criminal petition, my lord, again back, my lord. Page 27, your lordship has only seen. Now, my lord, from the FIR, my lord, the first submission I'll make is that not a single slang word has been stated in the FIR, my lord. On the previous week, my lord, I was sitting in this court and I have, my lord, one of the matter when your lordship was observing the 294 provision, my lord. My lord, neither it's a public place, nothing is there, my lord. No slang word mentioned in the FIR. Second part is that, my lord, the FIR itself says that there was not a single injury. Now, as far as these two petitioners are concerned, my lord, the FIR is silent whether they have molested, whether they have manhandled, or whether they have assaulted, my lord. These two petitioners, I'm only concerned with these two petitioners, my lord, right now, my lord. The FIR is completely silent. As far as the daughter-in-law, the second petitioner is concerned, my lord, she says that she immediately locked the door. And for the other petitioner, first petitioner also, she says that she did not allow me to enter, my lord. Now, my lord, and most importantly, my lord, one document I have applied before the Police Accountability Commission, my lord, which I'll be getting, my lord, in next week, my lord. The daughter of the first informant, my lord, filed a complaint against the investigation officer who conducted the investigation, and my lord, a departmental inquiry was placed against the investigation officer by my lord Justice B.B. Kotogi, my lord, sitting as the commissioner, my lord. Then my lord would kindly turn to page 37. Now I'll kindly see the conduct of my brother. He might, because at the behest of my brother, my mother is filing the cases against me. Page 37, my lord. This is a letter to the, my lord, this was the FIR, my lord. I'll just, because this was filed before the deputy commissioner, my lord, deputy commissioner forwarded an FIR, my lord. Now, my lord would kindly see this FIR was prior to the FIR which is in question before your lordship. Kindly see how the people have been proceeding against me, my lord. The FIR, my lord, page 38, my lord.
We have seen the ration card.
Yes, my lord. This is stayed by this honorable court, my lord. Because I have also filed a case, my lord, and this has been. Now at page 40, my lord, will find the title suit, my lord. This is the title suit filed by the husband of the petitioner number 1 against the tenant and bringing the pro forma defendant number 2, 3, 4, and 5, the legal heirs, my lord. And my lord, the prayer your lordship would find at page 46, my lord. Roman 1, my lord. declaration that the plaintiff being one of the legal heirs of late Bajranglal Bhatra and one of the co-owner of the property left by his father is entitled to his portion of rent being paid by the principal defendant to pro forma defendant 1 and pro forma defendant 1 has no right to collect the entire rent from the principal defendant. Then permanent injunction, then mandatory injunction. This is the pair, and lordship would find the title suit starts from 2017, my lord. Page 40, my lord. Once again, my lord, would kindly see page 40, my lord. Now, my lord, in this same case, my lord, page 49 is the written statement, my lord. Because I have not annexed all the
We
cases, my
understood
lord.
there is a civil dispute between you
Yes.
and your brothers.
Yes, my lord. And my lord, I have also annexed the orders, my lord. My lord will find page 107, my lord. The order of the learned civil court, my lord, for directing the parties to directing the my lord, for appointment of the commissioner and directing the commissioner to collect the rent and distribute the same within the legal heirs of my
That we
lord.
have
That is
seen.
there, my lord. This is now. And my lord, there is a probate case also, my lord, LA case also filed by them, my lord, and we have filed a probate case, my lord, that is at page 85, my lord. Page 85 is the probate case which I have filed, my lord. And the LA case is at page 94, which is filed by the my brother, my lord. Now, my lord, my basic case, my lord, I'll also rely on some of the judgment of the Supreme Court, recent Supreme Court judgments, my lord. Well, first I'm referring the judgment of Mahmood Ali and others, my lord.
Yes, what do you want to place it from here?
Well, here, my lord, para 11, my lord. Here, 2023 INSC 684. Mahmood Ali versus State of Uttar Pradesh. Now,
Yes.
para 11, my lord, the Bajranglal judgment has been referred, my lord. Now, my lord, internal page 12, my lord. Only point number 7, I am, my lord, relying, my lord, where a criminal proceeding is manifestly attended with mala fide and where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to inspire him due to private and personal grudge, my lord. Since my lord has seen in the civil suits also, my mother, my younger brother, my sisters, all are against me, my lord. Now, my lord, para 12, my lord. Now, para 12 is important, my lord. Internal page 13, my lord, of the judgment. At this stage, we would like to observe something important. Whenever an accused comes before the court invoking either the inherent powers under section 482 of the Code of Criminal Procedure CRPC or extraordinary jurisdiction under Article 226 of the Constitution to get FIR or the criminal proceeding paused, essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with the ulterior motives of wreaking vengeance, then in such circumstances, the court owes a duty to look into the FIR with care and little more closely. We say so because once the complainant decides to proceed against the accused with an ulterior motive for wreaking personal vengeance, etc., then he would ensure that the FIR complaint is very much drafted with all such necessary pleadings. The complainant would ensure that the averment made in the FIR complaints are such that they disclose the necessary ingredients to constitute the alleged offense. Therefore, it will not be just enough for the court to look into the avertments made in the FIR complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the alleged offense are disclosed or not. In frivolous or vexatious proceedings, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the averments, and if need be, with due care and circumspection, try to read in between the lines. The court, while exercising its jurisdiction under section 482 of the CRPC or Article 226 of the Constitution, needs not restrict itself only to a stage of a case but it is empowered to take into account all the overall circumstances leading to the initiation, registration of the case, as well as the materials collected in the course of investigation. Take, for instance, the case on held, multiple FIRs have been registered over a period of time. In this, it is in the background of such circumstances, the registration of multiple FIR assumes importance, thereby attracting the issue of wreaking vengeance out of a private or personal grudge as alleged.
Yes, you are appearing for the respondent.
I'm, my lord,
Make it
I'm appearing for the respondent number 2.
Hmm.
My lord, first of all, I would like to draw your lordship's kind attention to the case number 45 of the criminal petition. Why the 45 cases have been filed by the husband of the present petition? Kindly peruse the page number, para number 60. What he wants, that as per the will, the plaintiff is entitled to half portion of the rent being paid by the principal defendant to the pro forma defendant number 1. As such, the plaintiff is entitled to 7,515. So far, this present suit is filed. In all the cases, his claim is, if your lordship kindly peruse the page number 44 of the criminal petition, para number 13, the total rent is 15,030 rupees. And his claim is, in para number 16, that 50% should be paid to him. And now, my lord, please come to page number 73 of the same criminal petition, where in para number 30, my lord, it is the present, the respondent, they have stated that there are total 5 legal heirs are there, and all the 5s are entitled to 20% each. You have categorically stated that he is not the husband of the present petitioner number 1. He is not entitled to 50%. Because there are 5 legal heirs, and 5 should get 20% each. Now, my lord, he has based this thing, and when he has filed a receiver, appointment of the receiver. We have said that yes, let the receiver be appointed, but the entire maintenance of the building, the marketplace, that should be done, is being done out of the monthly rental income. So let the receiver to meet the expenses, and thereafter the balance, whatever remains, it may be distributed among all the 5 in equal share basis. That was the receiver appointment.
What do you want to show? You are on the affair.
Now, my lord, this is so far as the civil matters is concerned. On the basis of which this present writ petition, the quashing petition has been filed. Now, my lord, that what is the basis of this present criminal petition? Where do the petitioners stand? There are sufficient materials in the FIR as well as in the statements recorded. If lordship kindly peruse the FIR dated, the additional affidavit that has been filed on, it is at page number the first affidavit, it is filed on 15/12/2023. That affidavit may kindly be perused and the statements are recorded there. And in some of the translated copies, Lordship will find that what is the actual statement given before the IO that has been wrongly translated.
Kindly show.
Now, my lord, kindly. That here in page number 144. The petitioner number 1 begs to submit that on the plain reading of the statements of the witnesses under section 161 of the Criminal Procedure Code 1973, which were recorded by investigation officer. During the investigation, it becomes crystal clear that part of the informant, he had made a false, concocted and baseless story with some malicious intention only to harass the petitioners and malign their image in front of the society at large. It is to be found that the pure civil cases, my lord, assaulting the mother.
We are
and-
not against that Arvind Kumar Batra.
No, that is, my lord, it is categorically stated that how she has been victim. Here, the statement of Jashoda Devi, the informant in the instant case, during her statement before, they have mentioned an excerpt of the statement. I sent my maidservant to the room, in second floor. I have 3 rooms in the second floor, but my grandson Narendra Batra's wife Meenakshi did not open the door. When I went there, my son Arvind Batra and his wife Santosh Batra came, locked the house, and after that they misbehaved and assaulted me. Then the statement of Sangeeta Sharma during her statement before the IO stated, my mother-in-law have 3 rooms in the second floor. Arvind Batra and his family members daily torture my mother-in-law physically and mentally. They are doing all this for the property. Then, my lord, Hemen Sharma stated that during her statement before the IO, as follows: yesterday morning, when my grandmother went to second floor, Arvind Batra and his family scolded her with abusive language. It is their criminal petition, their affidavit itself shows that how the offenses have been committed and what the law requires. Law requires at this stage of this framing of charge, the prima facie there are materials or not. They are full of prima facie material. And it is the very criminal petition itself discloses. Now, my lord, my learned friend has referred the judgment. What the judgment said, kindly, if the lordship kindly peruse the judgment, it is given the benefit of doubt. Can he hammer that acquittal is on the basis of the benefit of doubt? And the court has made a statement that may falsely depose. PW 123 may falsely depose. This is the ground of acquittal. And if the lordship kindly peruse page number 181 of their last affidavit in opposition, affidavit they have filed. In that affidavit, page number 181 may kindly be perused. Guilt of the accused person beyond reasonable doubt. How they stand? Does this judgment help in any manner? Now, my lord, kindly, what is their statements is recorded in the by the IU. At page number 175, what they have stated that in their affidavit that Sangeeta Sharma made that yesterday night they physically and mentally tortured and assaulted my mother. This is their translated copy. Now, my lord, kindly peruse what is the statement. At page number 179, there Sangeeta Sharma stated that Juakali Ratipua, that in the morning they have given the translator yesterday at night. Similar is the case in respect of the Hemant Sharma. Hemant Sharma, he has given the statement in page number 175. They have given a false and wrong interpretation of the translated copy, where they have said that the Hemant Sharma said, my grandmother has 3 rooms in the 3rd floor, where there are puja materials. Yesterday morning, when my grandmother went to the 2nd floor, Arvind Batra and his family physically assaulted and harassed me. Here said that in the 3rd floor. Now, kindly, if Lordship kindly peruse the page number 180, there Lordship will find that he has stated that Ditya Mohalla, there they have made it as a 3rd floor. And the submission is being made that there is the animosity. What is animosity? The very petitioner's husband and the petitioner, they themselves have assaulted the mother.
Mr. Nandi, show the ingredients of section 294 and 305.
My lord, so far as they themselves have stated that it is.
Show us the ingredients of section 294.
My lord.
Can you read the provision of section 294?
My lord.
My lord, I've quoted in my
294.
petition also.
294. My lord, 294, options, acts and songs. Whoever do any annoyance of others, does any options act in any public place, or sings, recites or utters any option song, blad or words in near any public place. They themselves have stated that it is a marketplace. And the floors are there where the tenants are there. That is there that the 45 cases they have instituted. This place itself shows that there are tenants in all the floors. Can it be said that it is a private place then?
When there are tenants, it is a marketplace,
Yes,
a public place.
it itself is a public place.
Then, my lord, not a single independent witness is there, my lord. All family members have deposed against.
That is whatever evidences has been recorded by the IO during the investigation. Those evidences itself shows it is their part. If they have stated any false, let them be trial during the course of trial. Let them put the questions to the concerned witnesses that they have made any false statement. Does it give any power to come up with this court alleging that they have given false statement? You prove that first it is a false.
Okay.
Then, my lord, there are also materials that it itself shows that the assault is there.
By whom?
By here they have already stated by all the force, the Arvind Batra and his family members. And the evidences that.
The FIR for yourself.
My lord.
Read the FIR.
I read out from the translated copy.
Read the English one.
Prayer, subject, prayer for intervention and action as regards the illegal acts of my eldest son and his family members. Sir, I have the honor to inform your kind self that since after the death of my husband, late Bajranglal Batra, in the year 2016, my eldest son, Sri Arvind Kumar Batra, and my grandson, Sri Narendra Batra, have been constantly torturing me, both physically and mentally. Their whole intention is to drive me out from my husband's property. Since after the death of my husband, my youngest son, Sri Anil Sharma, has been taking all attention and care of me. Yesterday, 13/6/2019, at about 8 a.m. in the morning, I sent my maidservant in the 2nd floor rooms, wherein 3 rooms I have been using for dwelling and religious works, and I have various household properties but my granddaughter-in-law did not open the gate. Thereafter, when I went to open the main gate to enter into my rooms in the second floor, my eldest son and his wife, Srimati Santosh Patra, came up and locked the gate. And instantly, when I objected them, and after a few seconds, I came down, Sri Arvind Batra manhandled me and called at me in objectionable words and slang utterings. Prior to today incident, also Arvind Batra physically assaulted me and misbehaved with me. But instead of arguing with him, I reported the matter to Bharalmukh police station. But police illegally favored Arvind Kumar Batra and said without proper evidence, I will not take up such action. I am at present 82 years, and due to illegal and shameful acts of eldest son Arvind Batra and his family members, I have been suffering both mentally and physically at the fag end of my life. And today, I have been forcibly prevented and restrained me to enter into my dwelling room. I therefore pray your intervention into the matter and kindly pray a visit to my house and do the needful and save me from my elder son and his family members, so that being a widow, I can live rest of my life without facing mental and physical harassment, assault. I will be highly obliged. And this has been translated and it is given before this lordship.
Type copy.
Now, my lord, there are sufficient materials, and when IO investigated, they have enclosed in their affidavit. In the affidavit, whatever statements are, those are sufficient to face the trial. Now, what they have come up. Now, kindly peruse the lower court's order they have annexed. And in the annexed order, my lord, it starts from this very trial court's order has been enclosed. Yes, my lord, it is in the first affidavit. Make annexure number 4 and page number it is. That when the learned trial court has fixed it for page number 153 may kindly be paged. From 2022 onwards, 18/11/2022, accused person are present, copy is furnished to the accused person fixed for CC. And thereafter, they have come up with this petition and they are not participating in the hearing of the CC.
No, my lord, CC has not been done, my lord. We have been appearing at each and every date, my lord. CC is not taken up by the case, my lord.
CC is not taken up because of this case. There they have already mentioned, if the lordship kindly peruse page number 154, 17-2, seen the petition number 6009 filed by the accused Srimati Santosh Sharma and Meenakshi Sharma stating that they had preferred an appeal before the Honorable Guwahati High Court, and the Honorable Guwahati High Court by order dated 10/2/2023 called for the scanned copy of the instant case record from this court. Xerox copy of the order dated at the 10/2/2023 has been submitted. Heard, accused persons are directed to submit the latest copy of the Guwahati High Court order. So on this basis, they are avoiding the CC stage. Now, my lord, in this particular case, I like to refer this authority of Honorable Apex Court. This is reported in Live Law 2023, Live Law SC 292. Here, I just read out the para 4.2.
Give us a copy.
My lord, I am providing this. And here, I just read out the relevant portion. That thereafter, the conclusion of the investigation, the accused persons have been charge sheeted. Thereafter, the High Court has erred in observing that at this stage, initiation of criminal proceeding or public proceeding is malicious. Whether the criminal proceedings was or were malicious or not, it is not required to be considered at this stage. The same is required to be considered at the conclusion of trial. In my case, in any case, at this stage, what is required to be considered is a prima facie case and the material collected during the course of investigation which warrant the accused to be tried. This is the authority, my lord, I rely. And all the materials, whatever they have brought by additional, by the affidavit, this itself shows there are prima facie materials against all the accused person. So this criminal petition has got no leg to stand. They have brought this civil suit. In the civil suit, his husband prays for the 50%, where we say that no, all are entitled to 20%. And that 50%, on that basis, he has filed all the 45 cases. So in view of that, my lord, I respectfully submit that this criminal petition is liable to be dismissed and the accused person be directed to appear and the trial court may be directed to proceed with the trial after hearing this CC. Deeply obliged, my lord.
My lord, I'm just placing two more Supreme Court judgments, my lord, recent, my lord, authored by my lord Justice J.B. Pardiwala, my lord.
Yes.
Well, on the similar line which I read out of Muhammad Ali, my lord, on the very same line, and my lord. And the other judgment which I wanted to place before my lord is that at this stage of after filing of the charge sheet, also lordship can go into the aspect of quashing the FIRs and the charge sheet, my lord. That is the judgment, my lord. If my lord permits, I'll place that judgment also, my lord. A.R. Mohan, my lord, that was authored by my lord Justice B.R. Gavi. This is a recent judgment, my lord, of the Honorable Supreme Court in March 2024, my lord. I'm placing this judgment also, my lord. So, my lord, in my respectful submission, my lord, even the FIR, my lord, in the face of the FIR, my lord, no any ingredients are made out against these two petitioners, my lord, first part, my lord. Then, my lord, I've seen a recent judgment of 2024, which has been between the parties, my lord, wherein the learned court below has already observed, my lord, the previous and the existing enmity between the parties, my lord. That apart, your lordship would find the 164 statements have been only given by the informant, the son, the daughter, who had already been witnesses to the cases there, my lord. So, my lord, and that apart, my
Yes, Ms. Jahan.
As far as the squashing is concerned, lordship knows the subtle proportion that if it makes out a cognizable offense, commission of a cognizable offense, it cannot be. Now here the ingredients are 294.
Only with regard to the petitioner, not with the others.
Yes, but section 34 is there in the FIR, registered under the common intention. That is, of course, the FIR does not prima facie show the involvement of the ladies, but section 34 says and the 161 statement shows, and he has also challenged the charge sheet. And ingredients of 294, of course, that has to be in public place where public has access. This is what is defined, a street, a market, or similar kind of places where people go. Here, I'm not clear, of course, petitioner and the respondent will know whether second floor is also open to the tenants. Normally what happens, according to the FIR, what I see is that the son and the daughter-in-law, they stay in the second floor. And the mother perhaps on the first floor. So, but mother has few rooms in the second floor. She is not saying that she is staying there. She is saying that she had 3 rooms there, one used for religious purpose. When she wanted to go there, she was obstructed. And it is the contents in the FIR is there that they had been, in the first paragraph it is written, they have been assaulting them continuously. In the first paragraph, she said they have been torturing me physically and mentally since long. What she meant is this. And then on 36, 2019, when maid servant went, she was not allowed to enter. Then she went to enter into my rooms in the second floor. And my elder son and his wife came up and locked the gate. And instantly when I objected, after few seconds, I came down. She did not say they had done anything to them. She said after few seconds, I came down. Sri Arvind Batra manhandled me and called me in all objectionable words and slang utterings. Here, petitioner is not there. She is not named. But in 161, as my learned friend had shown, it's there. What she said is both of them had done it. Then the next paragraph,
161, page 164.
164. Those are 161, it seems he had read from the additional affidavit.
That's an additional affidavit.
That's an additional affidavit. Not only, he is one. 161, yes, he has annexed also by writing them in English. Lordship, Yashoda Devi, she is.
Vernacular, 161.
Yashoda Devi कौन है?
Informant.
Informant. Yes, Yashoda Devi, Lordship can go to page number 164. He has continuously paginated it. 164. I'll read it from here. মোৰ নাম আৰু ঠিকনা so and so. Lordship got it? 164, yes. মোৰ নাম আৰু ঠিকনা so and so. মোৰ স্বামী so and so পৰা মোৰ ল'ৰা শ্ৰী অৰবিন্দ আৰু মোৰ নাতি নৰেন্দ্ৰ মোক
Atrai. মোক প্ৰায়ে শাৰীৰিক আৰু মানসিক
অত্যাচাৰ কৰি আহিছে। সিহঁতে মোৰ স্বামী so and so
সা সম্পত্তি কাঢ়ি ল'ব বিচাৰে। মোৰ স্বামীৰ মৃত্যুৰ পিছত মই মোৰ অন্য ল'ৰা অনিল শৰ্মাৰ চোৱা চিতা
মোক চোৱা চিতা কৰে।
চোৱা মেলা কৰে।
চোৱা মেলা কৰে।
ইংৰাজী 13/6/2019 তাৰিখে ৰাতিপুৱা 8 মান বজাত মোৰ ঘৰত বাস কৰা ছোৱালীজনীক মোৰ বিল্ডিঙৰ দ্বিতীয় মহলাত থকা ৰুমলৈ পঠিয়াওঁ।
তাত মোৰ 3টা ৰুম আছে।
মোৰ 3টা ৰুম আছে। কিন্তু মোৰ নাতি নৰেন্দ্ৰ ভাট্টাৰ পৰিবাৰ মীনাক্ষী শৰ্মাই দৰ্জা খুলি নিদিয়ে। তেতিয়া মই মেইন গেটেৰে যাওঁ।
সেই জেগালৈ
মই তেতিয়া মেইন গেটেৰে যাওঁ। তেতিয়া মোৰ ল'ৰা অৰবিন্দ ভাট্টাই আৰু তেওঁৰ পৰিয়াল শ্ৰীমতী সন্তোষ ভাট্টাই আহি
ঘৰটো লক কৰি দিয়ে আৰু পিছত সিহঁত আটায়ে মোক বহুত বেয়া কথা ব্যৱহাৰ কৰি মাৰধৰ কৰে। So
here she said সিহঁতে, but in the FIR she came down and thereafter mentioned the name of the
only her son.
Now if you come back to the second part,
Malati Karmakar.
She was the first lady who went up.
She is the servant, maid servant.
মই আজি 3 বছৰৰ পৰা ইয়াত কাম কৰাকে আছো। মই আইতাক চোৱা মেলা কৰোঁ। আইতাক খুৰা অনিল শৰ্মাই চোৱা মেলা কৰে। আমি বিল্ডিঙৰ প্ৰথম মহলাত থাকোঁ। যদিও দ্বিতীয় মহলাত আইতাৰ 3টা ৰুম আছে। যোৱাকালি ৰাতিপুৱা 8 মান বজাত আইতাই মোক ওপৰৰ ৰুমৰ পৰা পূজাৰ কাপোৰ আনিবলৈ পঠাইছিল। মই তালৈ যোৱাত আইতাৰ নাতি বোৱাৰী মীনাক্ষী শৰ্মাই গেটটো বন্ধ কৰি দি মোক যাবলৈ নিদিয়ে। মই ঘূৰি আহি আইতাক কোৱাত আইতাক নিজে গৈছিলে। এতিয়া আইতাৰ বোৱাৰী শ্ৰীমতী সন্তোষ ভাট্টা আৰু গিৰিয়েক অৰবিন্দ ভাট্টাই গেটটোত তলা মাৰি দিয়ে আৰু আইতাক বহুত বেয়া আকাৰে গালি গালাজ কৰে। পিছত অৰবিন্দ ভাট্টা আৰু তেওঁৰ ল'ৰা নৰেন্দ্ৰ ভাটিয়াই আইতাক মাৰধৰ কৰে। পিছত মই আইতাক তেল মালিচ কৰি দিওঁ। ক'ব খোজো যে আইতাক সদায় সম্পত্তিৰ বাবে অত্যাচাৰ কৰি আহে। মোৰ ক'বলগীয়া ইমান। So these are the 2 persons who are in the place of occurrence.
Yes.
And it can be seen that they did not implicate the petitioners.
No, I mean, the mother said Hihote, so that will include Santosh.
That is in 161, but in the FIR, she clearly
Ah,
mentioned it is her.
FIR. But here he has challenged the all, FIR, charge sheet, everything. Charge sheet will be based on 161 statement.
Anything else you want to say?
Aru and what I want to.
Just tell us whether this ingredients of section 354 is there against the petitioners or not.
354, of course, the touching the key is like, oh, outraging the modesty. Here assaulting and manhandling part is there
By whom?
by as per here FIR, the wives do not come in the picture. But
Right.
yes, in the last paragraph, Lordship will see, save my elder son Anis so that I needful and save me from my elder son and his family members.
So that
This is only her third paragraph. I am presently 82 years and due to illegal and shameful acts of my elder son and his family members. That will include wife, son, son's wife, perhaps everyone. But then these are omnibus statement, not particular act. Illegally favored without misbehaved with me, but instead of arguing, yes, because since he has challenged the entire proceeding, so 161 statement has to be looked into. 161, the wife, the informant said about Santosh may not, she did not speak about petitioner number 2. Oh, Meenakshi also she said, Kintu Moor Nati Boari Meenakshi Sarma Dorja Kuli Nidie. তেতিয়া মই সেই জেগালৈ মোৰ ল'ৰা আৰু as far as I mean behaving with her badly, I mean Santosh comes in the statement of the mother and in the statement of the maidservant. She had spoken about all. Aita Boari, Srimati Santosh Sharma আৰু গিৰিয়েক so ঠেলা মাৰি দিয়ে আৰু আইতাক বহুত বেয়া বেয়া গালি পাৰে পিছত অৰবিন্দ বত্ৰ আৰু তেওঁৰ ল'ৰা মাৰধৰ কৰে পিছত মই আইতাক so she did not speak about Meenakshi. She spoke about petitioner number 1. মই তালৈ যোৱাত Meenakshi she says only that she locked the door while she wanted to enter. And Sangeeta Sharma, Hemant Sharma, who? Tenant. No.
Anil Sharma wife.
Okay. Anil Sharma wife. Aru Laura. Okay. Arvind Kumar. And the Anil Sharma's wife and the son is also examined under 161. The boy who is taking
They
care
were
of
not
the...
there, no?
Lordship?
They were not there.
They were not there. Now the question is whether 294 will come. 294, it seems, from the bare perusal of these papers, it doesn't seem that there were tenants there. It's a public place.
Do you mention in second floor there was any public place or not? No.
Normally what happens when these kind of buildings, the owners, they
Then we got
stay,
presumption.
stay in
Then
a,
we go on presumption.
but then the entrances are different, I think.
Yes.
Honey? That is again a fact-finding thing. That has to be, Lordship will not enter into those. But admittedly, it's a building, a commercial building, where so many tenants are there. So as far as whether tenants were there in the second floor, whether it's a public place, let the trial court go into. High Court will not. And 354 and along with section 34. There are no injuries and all, no? Injuries are sent. And I'm told there is an injury report also, along with the charge sheet. Harry, क्या found person? হেৰি হ'ল নেকি? Cognizance ল'লে?
CC hearing order.
The cognizance order ক'ত?
Cognizance order to file the plea to us.
NX লোৱা নাই নেকি? Cognizance ক'ত লৈছে? ইয়াতে হৈছে জানো? Against নহয়, ইয়াতে নাই হোৱা। Issue summons, okay. So, laid under section 506.
Their husbands were arrested.
Yes, my lord, husband and the
Their
their
husbands
husband was
were-
arrested, my lord. Immediately, my lord. That is why, my lord, this proceedings were initiated in the police accountability cell also, my lord. I placed the order also, my lord.
I mean,
This IO, my lord.
cognizance were taken under what sections I wanted to see? এইটো যশোদা দেৱী এয়া ন ইমান বেলেগ বেলেগ নাম যে
First order.
Hmm.
Containing next case.
A medical report, one medical requisition or medical report was considered. On perusing it appears that a prima facie case against Arvind Narendra Santosh Meenakshi under 323 is there in the cognizance order.
Only 323.
323 because there is injury report, physical assault. 150, page number 158 of some additional affidavit, no?
294, 323, 354.
Yes, along with 34.
Somewhere. In that.
Simple injury. Okay.
Restricted movement of knee, right knee.
82 years old.
Etu ENT bleeding, okay, vomiting, কিবা আছে ন? Restricted movement of knee, tenderness. It was to
82 years.
not a case for washing off. No, yeah. 150 follow no.
Cognizance taken or not, Mr.
Yes, cognizance taken.
Cognizance were taken, my lord.
Where is that order?
My lord, the order is at page.
ইয়াতে আছে নেকি? নহয় নহয় তই লৈ গৈছ নহয় তই লৈ গৈছ
147, my lord. Hundred and 48, my lord.
Yes. Okay.
নহয় এইটো চাম না সিহঁতে এটাই গোটেইকেইটা মাৰপিট কৰে মাৰধৰ কৰে সেইটো আমি এইখিনিৰ ওপৰতে চাম নাই কোনে লিখা এইটো এইটো কৈছে আই ভগৱত প্ৰসাদ চৌহান এইটো এই প্ৰসাদ চৌহান ইজ দ্য পুলিচ অফিচাৰ ভগৱত প্ৰসাদ পুলিচৰ মানুহ কেতিয়াবা ষ্টেচনত গৈ এনেকে ইহঁত দুটা নাই বুলি কিয় কৈছা এই অনিলৰ ঘৈণীয়েক আৰু হেৰি ইহঁত দুটা নাই বুলি ক'লো যে ইনচিডেণ্টৰ সময়ত নাই But washing আহিব when there are no material. Clearing the fire. সেইটো মাৰধৰ কৰা আৰু ক'ব নোৱাৰি সেইটো ক'ত যাব ইমান ডিছচাৰ্জত এটা কথা
Ms. Zahan,
Lot. That's it. Into 354, whoever exhort uses criminal force.
Please come to page number.
Page number, Lordship. One minute.
This is the reply.
Acha.
The suit
Reply to the suit, Lordship, page number,
starts at page 49.
Lordship. Yes, this is the written statement of 2, 3, and 5.
Come to page number 57. Page 57, para 40.
Paragraph 40,
Kindly read.
40, 40.
Yes.
That the averments made in paragraph 3 is not true and correct. It is to be mentioned herein that in total in the new RCC building part, in total, there are 11 tenants. In the old RCC building part, in total, there were 2 tenants. And in the Assam type house part, in total, there are 3 tenants.
Go on reading.
Lordship.
Go on reading.
It is to be mentioned herein that among the 2 tenants, among the tenants, 2 of the defaulter tenants has instituted in the court is he instituted in the court during the lifetime of late Bajranglal Bhatra.
Further, it is to be.
Further, it is to be mentioned herein that the plaintiff has recently started the business of hardware items in one of the shop room in the Assam type house part, and he is collecting the monthly rent from the tenants, see,
Such and such and such.
so and so, yes, possibly and illegally.
Then third paragraph.
It is to be mentioned herein that pro forma defendant number 3, since during the lifetime of late Bajranglal Bhatra, has been running his petty business in the ground floor of the old RCC building and the go down in the backside of the ground floor of the new RCC
Now,
building.
Here, the mention is in the which building. You have seen the tenants are in the which building, right?
Yes.
In the new building, 11 tenants.
Yes.
Whole Assam type house, 2 tenants. And the new building, there are 2 tenants. Old RCC building, 2 tenants. New building, 11 tenants. And the Assam type house, there are 3 tenants. Right?
Yes.
Now, please come to page number. The suit.
So these are different building, new RCC
And
building.
there is no mention. So it be a public place, even if we assume. Which particular building they are residing, they did not mention. So now please come to page number 47.
Things were not clear. Page number 47, Lordship.
Yes. There's the schedule of the suit premises.
One shop room at the first floor in the building known as Uma Place.
Uma Place. Now where they are residing?
They are
Second floor. Where they are residing?
informants resides in the first floor and she has
Of
room in
which
the
building?
second.
New building, old RCC building, new RCC building, or at Uma Place?
Where? They will know.
I think Uma Place.
We don't know.
We don't know, yes, my lord. As far as the affair is concerned, I don't know, my lord.
The address given is also very clear. It's not there at all.
SC Road, Adga.
So assuming the incident occurred at second floor.
Second floor.
And there is no tenant in the second.
In the Uma Palace.
Where is that Uma Place?
Clearly तो लिखा ना है वहाँ पे building.
ये तो लिखा नहीं क्या था
नहीं ये कहाँ पे?
वो क्या लिखा भाई क्या दिया था
No. It is to be mentioned herein that in total in the new RCC building part, there are 11. New RCC building. Old RCC building one, same building owner.
See, no mention. We are not on that. We are asking Ms. Zahan to clarify. Is there any mention in the FIR in which particular building that incident took place?
My lord, so far as the second floor part is concerned, there is a suit is there.
We are not on that. Hardly. Mr. Eturi. Counsel appearing for the petitioner. And I'm at Sir Jahan Lane, additional public prosecutor. Appearing for the state. Respondent. Also heard Mr. D. Nandi. Learned counsel appearing for the respondent number 2. The informant. Complainant. In support of his argument, Mr. A. Tiwari, learned counsel for the petitioner, relied on the decision of the Honorable Supreme Court in the cases of Mahmood Ali, M.A.H. M.O.O.T. Ali and others versus State of UP and others. Criminal appeal number 2341 of 2023. Decided on 0808-2023. A.M. Mohan versus the state represented by S.H.O. and another criminal appeal arising out of SLP in bracket criminal number 9598 of 2022 decided by three honorable judges. The apex court on 20-03-2024 and Salib SALIB alias Shalu SHALU alias Salib SALIM versus State of UP and others. Reported in 2023 11 SCR 58. Decided on 0808. On the other hand, Mr. Nandi, led counsel for the respondent number 2, placed reliance on the decision of the Honorable Apex Court in the case of Central Bureau of Investigation versus Aryan Singh. Decided on 10-04-2023 in criminal appeal numbers 1025-1026 of 2023. As reported in live law. Ms. Jahan Lane, additional public prosecutor, submitted that charge sheet in the case was filed on 25/10/2019 by CS number 113 of 2019. Under sections 294 of the 323 of the 354 of the 34 IPC. Even against the petitions. And by order dated 12/02/2021. Learned Sub-Divisional Judicial Magistrate number 1, Kamrup Metro Guwahati. In PR case number 435 of 2021 arising out of Borolomuk Police Station case number 309 of 2019 took cognizance of the offence under section 294 of 323 of 354 of 34 IPC against the petitioners and their husband, respectively Arvind Kumar Patra and Narendra Patra. Orders to be followed.
Lordship.
Deeply obliged, your lordship.
Oh, yes. Lordship, I've spoken to the Sila Pothar OC. He said that there is no GD entry. They have not even received any FIR. Lord, if Lordship wants a written instruction, I can get it. But he is very
No,
clear.
this is from Lokhipur.
Lakhipur, yes. Lakhipur,
Kachar.
Kachar.
Okay.
Rehna Begum Chaudhary, there is no FIR from Rehna Begum Chaudhary alleging that after bail she was again harassed. Into no GD entry was it? This one, I've told them about this.
The subsequent, the previous case,
And their charge sheet is filed. That is reflected in your lordship's order. Here, what the copy that he has produced, it's written received. But I don't know, let me get a written instruction then,
that will be better.
lordship. And he can give me a copy, I'll forward them this copy as well. Eh, প্রথমে আমি বুঝি না। এই ভালো প্রথমে আমি
But cancellation of bail, just say,
yes.
that can be an issue only when the bail orders are violated.
This is what they are saying. They are again harassing the informant after getting bail.
It appears that on 28/04/2023, laws and affair before the officer in charge of Lakhipur Police Station, District Kachar, stating that the respondent numbers 2, 3, 4, 5, 2 and 3. Written how and to face or to face the dire consequences. If she fails to withdraw her earlier FIR, there is 28022023 being Lakshipur PS case number 56/2023 registered against them under section 120B, 498A, 341, 342, 325, 313, 539, related with section 67 of the Information Technology Act. Ms. S. Jahan, an additional public prosecutor. Next, on the next date fixed,
That's
the officer in charge of Lakshipur Police Station, Kachar, shall submit a report as to whether the petitioner on 28/04/2023 submitted any such FIR against the respondent numbers 2 and 3 or not. If so, the concerned GD entry number as well as the case number, status of the same. List on. Yes, ma'am, when?
Lordship, any date. In fact, yesterday I also spoke to them. Any date,
18th,
18th of September.
copy of this order, along with the copy of the FIR dated 28/04/2023, lost by effect before the OC, Lakshipur Police Station, District Kachar.
I am applying for the
Yes.
respondent.
All right. Okay. Yes. Yes, yes.
May I please, your lordship? Lordship, morning time we have to make a mention. My lord, in this case, my lord, Elchoras call for my lord, last occasion. I must not receive my lord.
You made a mention in the morning.
Morning, yes, ma'am.
It's a reminder. Where is the office note dated 14/08/2024 and 30/08/2024? Where is the order dated 12/08/2024 as well as the office notes? Look at it first. It's a reminder. The principal magistrate, JJB Kamrup Metro Guwahati, for the scan copy of the records of PRC JJB case number 04 of 2023. List on 19th,
There is interim order, my lord.
iPad to-
Is until further.
May I plead your lordship? Lordship. Today my senior is out of station. Time maybe give him for 1 week, lordship.
Only priority counsel for the petitioner. List of weeks on a date to be fixed by the registrar. Same order as well.
May I plead your lordship?
Yes.
So we have received a copy of the affidavit filed by the respondent, my lordship, respondent number 2.
So what remains?
Actually, initially interim order was granted, then they preferred appeal. It was sent back, asking both the parties to give their assets and liabilities. We are giving our assets and liabilities.
We have also filed.
Even argument was done. The necessary order is to be passed.
My
now
lordship,
there.
here in this case.
So
what
at this
happens, my
stage,
lordship-
whether there is
No,
any
my lordship,
question of
what has
washing of the
happened in this
petition.
case, I will explain, my lordship. In the year 2015 March,
We are not on there.
We are not on that because
See, basically that amount, interim maintenance was considered 5,000 rupees. You have challenged in appeal. The matter has been referred back.
my
Now,
lordship, prior to that, what happened? When this is the second case of
There is
domestic
no
violence.
barring
My
for the
lordship, may I
second.
please, submit. This is the second case of domestic violence preferred by the petition. The first one was filed after separation in 2016. The husband and wife separated. The petitioner and respondent separated in 2016, living separately. They filed an application under the domestic violence, which is the DV case number 104 of 2016, my lordship. That is at page 27.
just tell us, Mr. Garudia.
Yeah.
The aggrieved person has a right to approach the appropriate court for under the Domestic Violence Act. If in first occasion, if there is no such favorable order, is it possible that in the second
My
occasion?
lordship, what happened, the disposal of that case, my lordship, the order is there.
that was withdrawn also.
No, that order is there, I've annexed. May I please?
That has been annexed.
It is at page 42, my lordship,
Hmm.
kindly see. First case, 2018.
Hmm.
Agree filed petition number such and such stating that the social welfare department has not mentioned the allegations of domestic violence in a domestic incident report and such. She wants to withdraw the instant case. She has also prayed for liberty to file a fresh case
That is
against
also
the
there.
respondent. The grounds shown by the aggrieved for the withdrawal are not reasonable in my opinion. However, it is a prerogative of the aggrieved whether to proceed with the case or not. As the aggrieved is not willing to proceed with the case and wants to withdraw for whatever reason she finds proper, she is allowed to withdraw on the same. As for granting the liberty to file a fresh case is not within the purview of this court's jurisdiction to allow reject the same. Agreement may do so on her own accord as their own risk. Case is disposed of.
Hmm.
This was withdrawn because he didn't get the monetary relief in the earlier case. In the earlier case, order dated my lordship 8/9/2016, page number 36.
Hmm.
Is the order which her prayers for monetary relief was rejected. At page 41, my lordship will find all interim orders were rejected.
Though we are not in the merit of that particular case.
My lordship, thereafter they filed an
Though we are
appeal
not
also.
in the merit of that particular case.
Yes, my
Please
lordship.
come to the third paragraph. The intention of the letter,
Our third paragraph, my lordship.
page 40.
Is 40.
Is it the correct proposition of law?
Page 40.
Kindly read.
The intention of the legislature was providing for provision interim measures to ensure that the aggrieved has sufficient means to sustain herself during the pendency of the trial. As the aggrieved is already getting interim maintenance in pursuant to proceeding under section 125 CRPC at this stage, I see no reason to grant her further interim maintenance for herself and her child.
Is it the correct proposition of law? Has been laid down by the Honorable Supreme. Taylor,
No, no,
is it the correct proposition of law?
no, my. Thereafter,
So-
they filed an appeal also against this order before the session judge.
Hmm.
That was also not allowed.
After withdrawal, after, okay.
Oh,
After
against
the
this order.
interim, right.
Against what? That was also when dismissed the appeal. Thereafter, they withdraw this first case.
Then
Then they filed this second case. After the second case was filed, we argued about the LCR. If the LCR has come, it will come before this, before your lordship. We argued about the maintainability of the case, my lordship.
Hmm.
Subsequently, my lordship, COVID was there at that point of time.
see,
And-
has been, the petitioner, the restful respondent has pointed out these facts. The matter has been referred back to the.
No, my lordship, that is also there. I will come to it, my lordship, because
They have not challenged at all.
no. I will come. Here, sir.
They have not annexed even.
I will come to it.
Yes, please.
My lordship, what happened thereafter? That interim order of 76.
No, 18/12/2020.
18 12 the तीन order play.
उनकी दिया ही नहीं मैं
18 12. Yes, my lord. This is
18/12/2020.
yes, my lord. In this case, 18 12, 18/12/2020, the interim order against which we filed an appeal, my lordship, that was passed in absence of the respondent, my lordship.
Hmm.
It was in here, my lordship, they have stated, the court below had stated that we had not even filed the written objection, but we had filed it. And as such, after argument in the success judge, that appeal was remanded back to file the assets and liabilities. Prior to that, my lordship, we did not even get the proper opportunity argued before the court below about the maintainability of the case, my lordship. LCR will speak, my lordship. The orders are there, fixed for hearing.
No, since the matter has been considered in an appellate forum. and has
Appellate
been-
forum only considered that the monetary part, my
What is the
lordship.
direction issued by the Learned Appellate Forum?
Yes, my lordship. No, that was the monetary part was set aside.
Page 79 your lordship.
79, my lordship, the monetary.
Para
part,
12.
Para 12 and 13 is set aside, my lordship. In the second case also, the appellate court did not consider the monetary relief, my lordship. And the trial court also did not entertain the argument of the legality of this case, my lordship. Sustainability of the second application, because they are not in a domestic relation at present.
Where you have mentioned that you have preferred an appeal
My lordship.
and the appellate court, after considering the matter, has remanded that.
After, my lord,
Where you have mentioned,
No petitioner, where you have mentioned regarding this appeal, President.
where you have mentioned that you preferred an appeal against the interim maintenance.
since that was disposed of, my lordship, I couldn't,
Where you have mentioned,
I have not mentioned, my lordship, this, about this appeal, my lord. Earlier appeal, those are disposed of matters, my lordship.
where is your appeal? Copy of the appeal, Mr. Talukdar, do you have a copy of the appeal?
Appeal memo, I don't have, but the order is there. I have a next.
Order you have already annexed.
I have already, the appeal. That memo is not there with me. বাকি ডিসপোজৰ বিলাকতো দি আছে 104 ডিসপোজৰ দিছে এইটো ডিসপোজৰ নাই দিয়া দিলে চোন দিয়ে তাৰপিছত ডিসপোজৰ দিছে 498 পৰা ডিসপোজৰ নাই
Yeah. Mr. Talukdar, Superior, just give us a copy of the memo of appeal on the next day.
On the next day.
When?
After a week,
Friday?
next Monday, Lord.
Friday?
I'll be out of station for 3 days, so next Monday, Your Lord. Okay.
Listen Monday. And I'm willing both the petitioner as well as the respondent to place the copy of memo of appeal filed by the petition before the learned Listen, Judge Kamrup Metro Party. The order of interim maintenance at 18/12/2020 caused by learned as is there within the Modern Kamrup Metro Party in DB case number 76 M/2018 prepared by the respondent.
Item number 40.
What is the urgency?
Urgency, Lordship, some of the petitioners want to withdraw their name from the, they are not interested to pursue the matter. Therefore, they have filed an IA for withdrawing their name. That is the urgency, Lordship.
Let us see.
Lordship. Obliged.
May it please your lordship. Lordship, the client already took the brief from me last year itself, and a copy of the no objection certificate was also submitted by me before the Joint Registrar Judicial Office, your lordship. But the same was not reflected and my name was there, your lordship. So I beg your pardon, morning I failed to appear before this honorable court. Lordship may pass appropriate order.
On which date your brief was taken back from you?
Lordship, on 1/4/2023, your lordship, last year itself.
Next case. Learned counsel for the petitioners submitted. That earlier he used to represent the petitioner. From last April, which is the date?
1st April 2023.
On last 1st of April 2023, petitioner took back the brief from her. And since then, she has no information from the petition, from the side of the petition. She also submitted that in the threat app trigger, she has intimated the registry of the school. Placed on Friday, the paper.
My lord, may I submit one thing? Lordship may continue with the case if people so desire.
What we'll do on Friday, we will just have a report if any new councils have been engaged by the petition. If so, then
My,
we will
my lord, my submission will be that let the stay order vacated.
we'll do that. But before that, we are doing it because today Ms. Jain has submitted, she is no longer representing the petition. If in the meanwhile, petitioner has engaged some lawyer, it has not been reflected, the report will come. If there is a report that is not been engaged, then we'll pass the order. Even otherwise, we'll pass the order because there is a statutory provision in the Act 2017.
Because I have no objection if the case is continued, but stay order should be
We
vacated in
understood
my humble
because you
submission.
long back you have filed that application for vacating stay.
Yes.
Just that I'll take it. The stay order is in force since 11/01/2022 against the respondent number 8. Ex parte interim. And the respondent number 8 on 2/11/2022 filed an application for vacating class modify application for vacation modification of the said order is at 11/01/2022. Which is yet to be considered and disposed of. Next, place this matter on 6th with the report of the registry as to whether the petitioner in the meanwhile filed a fresh Okalatnama engaging new counsels for him or not.
Deeply obliged.
Lordship, I'm appearing on behalf of Mr. A. Chakoti. Okay. Lordship, in this matter, the final report has been filed at the before the court at Silchar. Okay, and the next date is fixed for hearing. Okay,
Which is the next date?
14 October. Okay. Or 14 October. Lordship, your Lordship may be pleased to fix the date after 14 October.
You have received the notice? You have
No,
received
no,
the
no
notice?
problem.
14th October is fixed for what?
For hearing, Lordship.
Hearing of what?
Lordship, the final report. I have yet to receive the summons, Lordship.
Probably it is for the information. Probably the petitioner might have filed a protest petition. You get a copy of the protest petition. We'll fix it after the vacation.
Okay.
It is already noted above in our earlier order that Police, after investigating the matter relating to matter, submitted a final report on 31/01/2024 in Silchar, PS case number 1880/2023. It is submitted on behalf of the petitioner. And at 14/10/2024 is the date fixed relating to the hearing of acceptance of the same final report. List on 28. Mr. Doctor. The next day, just produce the protest petition if any filed by.
Yes. I would like.
Yes, ma'am, what's the matter about?
Your Lordship, this writ petition is for the appointment of academic in charge. For the entry was granted to us earlier, but then an IA was filed by the opposite party and it was vacated. I am for respond number 4, Lordship. I want to file affidavit, Lordship, in this case.
Yes, yes.
I want to file affidavit, Lordship, in this case. I pray some time to file affidavit.
What remains? What remains in this issue? What was their prayer? Page 10.
Yes, Your Lordship, to put a stay on the order that was dated 4/4/2023.
You have challenged the respond number 7's appointment as academic in charge.
Yes, Your Lordship.
As on date, There is no in-charge principal in that higher secondary.
No. Yes.
Now, the order passed by learned brother vacating this stay order on 19th of February 2024. Please come to para 7 if you have the order of 19th of February. Or you can read from para 5. Read the order from paragraph 5. Do you have the copy of the order, 19th of February? You don't have. Nineteenth of February, paragraph 5 only, you read.
Pursuant of the impunch order dated 4/4/2023, issued by the Inspector of Schools, who is in charge principal of the state school, find that same clearly mentioned that the applicant or respondent number 4 is allowed to act as the academic in charge of the higher secondary school for the smooth running of the school environment and academic side. It is to be taken note that the interest of the students and the school should be given preference to any other individual dispute with regard to holding of charge by the teacher of the state school.
Thanks, very good.
Since the order dated 4/4/2023 allowed the applicant or respondent number 4 act only as the academic in charge for the betterment of the school while holding the in charge principal to be himself by the inspector of schools, I prima facie find no infirmity in the impunched order dated 4/4/2023. The appointment or arrangement to hold the in charge of hold the charge of the academic in charge for the betterment of the school cannot be constructed to be an order allowing the applicant or respondent number 4 in charge of the principal of the school.
Thereafter,
In the view of the above, I am of the prima facie view that the order dated 4/4/2023 allowing the applicant or respondent number 4 to act as an academic in charge cannot be considered to be an order for allowing to hold the in charge principal of the state school.
then
Thus, I am of the view that the order dated 19/10/2023 is liable to be modified. Accordingly, the applicant or respondent number 4 shall be allowed to act as the academic in charge of the Simulbhari Higher Secondary School forthwith.
now have you challenged this order?
Um,
If you have not challenged this
we
order,
have,
the finding of the learned
No,
student
you-
already
are-
passed earlier.
Your Lordship, we have challenged the order through an WA, but we have withdrawn it.
You have withdrawn it.
Yes.
So what remains?
Mhm.
That finding of the coordinate bench of this court that allowing the respondent number 4 to work as an academic in charge is not the headmaster in charge or not the principal in charge. That will always remain. So in that case, your writ petition also. Got it?
Yes.
After considering entire aspect, the coordinate bench has given its finding on merit of it. Right? If you have challenged and withdrawn. Do you have the number? Do you have the number, read number?
Retable number 5784. Read appeal,
Read appeal number.
155 of 24.
Yes, you want to file affidavit?
There was nothing left, only academic in charge.
Why do you want to file affidavit?
Only for academic in charge lordship for smooth functioning of the school lordship for at
Why
least,
do you want to file affidavit?
because on last occasion they are insisting lordship for our affidavit. This is my lordship. While stay was vacating, so I am praying for. Otherwise, nothing left lordship. Because both person are not eligible for principal, perhaps. That's
155, you say?
155. Hmm. 155.
Who preferred that writ appeal? Second number. It is by some Jahirul Islam.
Yes. Negative.
Against you.
Then he is a third. Respondent.
What's your good name?
I'll see.
Counsel for the petitioner. You are appearing for 123
Yes, Your Lordship.
and MSP Bachati, Learned Counsel for the person number 4. Grievance of the petitioner is that without considering his status and seniority, the inspector of schools by an order, inspector of schools, Golpara, district circle, Golpara, by an order number, under number ZDC, public answer, public PT, dash Roman 2, public 2022 dash 2023, public 4573, dated 04/04/2023, allowed the respondent number 4 to act as an academic in charge of Simulbury Higher Secondary School on the basis of the resolution number 1 dated 22/03/2023 of the School Management and Development Committee of the said higher secondary school for smooth running of the environment of the school and its academic side, as the earlier in-charge principal of the school retired from service on 22/02/2023 on attaining the age of superannuation. Petitioner contended that is the senior most assistant teacher of the said higher secondary school, whereas the respondent number 4 was only a contractual teacher. It is to be noted herein that pursuant to the order of the state government in its education department, Simulbury Embry School was amalgamated with Simulbury High School. Simulbury Higher Secondary School was provincialized by the state government education department by order dated 30/11/2021, and said Simulbury High School was subsequently amalgamated with Simulbury Higher Secondary School. In Simulbury High School, the petitioner was the senior-most assistant teacher, whereas the respondent number 4 was only a contractual teacher whose seniority was at 5th position. Agree with the order of the government, order of the inspector of schools, Gwalpara, dated 4/4/2023, allowing respondent number 4 to hold the academic charge of the Simulbury HS School. Petitioner filed his petition. Initially, the court, by order dated 09/10/2023, considering the provision of Rule 12 of Assam Secondary Education within bracket provincialized schools, that it was Service Rules 2018, came to the view that the principal of a higher secondary school is to be appointed by the Director of Secondary Education Assam by following the procedure provided therein, whereas the impugn order dated 04/04/2023 was passed by the Inspector of Schools, Gwalpara, allowing the respondent number 4 to be the in-charge principal of the said Simulbury Higher Secondary School, who being not the appointed authority and also below the appointing authority, as per the provision of Rule 12 of the said 2018 rules. With regard to the said ex parte stay order dated 09/10/2023, the respondent number 4 filed an interlocutory application being IA 72/2024, and a coordinate bench of this court, after hearing the petitioner as well as respondent number 4, and also standing counsel in the education department of the state, came to the finding 678. And accordingly, accordingly, the coordinate bench by order dated 19/02/2024 vacated the ex parte stay order dated 09/10/2023 and allowed the respondent number 4 to act as the academic in charge of the Civil High Secondary School. I agree with the same. It is submitted by Ms. Nanduparati. The petitioner preferred a appeal, being read appeal number 155/2024. However, on 15/05/2024, the petitioner had withdrawn the said read appeal. As the court in advance, after hearing the parties, prima facie came to the view that an act as an academic in charge of an educational institution cannot be considered to be an order for allowing to hold the in charge principle of the said institution. And since the petitioner failed to establish any fact, any material before the court, the respondent number 4 was allowed to hold a post of in charge principal of such and such a higher secondary school. This state petition being without merit stands dismissed. I do order paragraph 2. Yes. Yes, Mala.
On the earlier occasion, the entire records were not here. Entire records, Nasil, no, part of the records were there.
Everything is there now to go through. Let us know.
Lordship, part of the records were there on the last occasion.
Now it has come.
Acha. 3 files are there.
Understand. Yes, it is there to go through. Let us know on the next.
Lordship.
Pursuant to the order dated 05/08/2022, registry has received the 11 records from the court of London. Placed on 9th.
Lordship.
Earlier incidents as the unlikely placed on 9th. Till
161 लगाएछ न
सब लगाएको या सब
एकछिन त कलर हो
My lord, earlier interim modem everything. Please do. Deeply obliged, my lord. It is. Sure. I do.
Which item? Which item? 13. I was supposed to bring some record, no?
Report is very important.
No, Lordship.
Your Lordship, I am for the Canara Bank and my 50 lakhs has been seized on 13/6.
We have the report.
No,
No,
Lordship,
Your
in
Lordship.
fact, our intimation had gone on 26/7. But report not gone. Lordship will take it up on Thursday, Wednesday being a holiday, I'll get the report.
From Karimganj, you'll get it.
Lordship, I'll have it through telephone.
But get a WhatsApp so that you can give us, or you can through email, you can give us something in writing.
Lordship.
Okay.
Jimma of the cash amount.
Yes, Your Lordship. It's 50 lakhs.
Friday,
Otherwise, Ambalal Sundar Bhai, even the cash amount can be given in Jimma, no issue.
but
So
whether it is in, let us
I'll get a written
get
instruction.
a report from the
Lordship.
because we do not know, it might be required for the investigation.
Lordship.
It might be required for the investigation of,
Uh-huh.
don't know at this
Can-
stage.
Your Lordship, one person has already been released on bail, Your Lordship.
Releasing bail and releasing this
Hmm.
amount in Zimma to
Two
different.
separate things.
And even it's an state enterprise, Your Lordship. so-
Okay, we'll sit there. When on 10th or on 9th,
Any day, Lordship. 9th.
list on enabling.
I go back.
My lord, this criminal petition has been filed mainly on, my lord, judicial question, my lord, raising judicial question, my lord. Here, what happened, my lord? The petitioner took loan, my lord, from the respondent company, my lord, respondent bank, my
In
lord.
this case, I am for IDFC Bank Limited, but I have never been served with the copy. And on the last occasion, my friend is not present.
Do one. Heard Mr. M. Islam Council for the petition. And Mr. M. Sharma. M. Sharma, right?
Yes, Your Lordship.
MD Sharma or M. Sharma?
M. Sharma, Your Lordship.
Learned Standing Council for the IEFC First Bank Limited. Will respond. Petitioner shall serve a copy of this petition along with the annexes of Mr. Sharma during the course of the obtaining the facility.
Well, in the court itself, my lord, I'm serving, my lord, I'm giving.
Friday, Friday.
Acknowledge, my lord.
এখন আপনার নেই।
Lordship, regarding increment of arrears salary effect from 16/11/19 to 28 to 21.
My lord, in this case, I am appearing for elementary education department. I pray for some time, my lord. As per my telephone instruction, my lord, director has asked to block elementary education officer for sending fresh proposal.
Just
My
Mr. Talukder,
My lord,
do you have the copy of the report? Copy of the
yes.
Please come to para 7 at page 18. The school in which the petitioner was working appears to be at the under the DI of Odalguri.
My lord.
If it is Odalguri, then the authority is BTC. Then petitioners was appointed in the Borongabari Dokhin Suba LP school, which is in Odalguri. Right?
My lord.
That was in the year 2002
Two.
or 2001, in fact. He was supposed to be released by March 2002. But coming back here at page 27, or 24 rather. He was appointed against Dorong district. How come a post of BTC can be here in the Dorong district? The reason we are asking you is this, because earlier the secretary filed a detailed petition seeking permission from the division bench of the court for adjustment of those teachers. Petitioner name was not there. Subsequently, he came. How can there be an inter-district transfer from BTC to non-BTC? Is it possible? Because it's a education is a transfer subject to BTC long back.
My lord.
Only the common DI was there, right? So Dorong and Udalguri. Apparently, the petitioner was appointed in the Udalguri district.
Initially.
In the Udalguri division
My lord.
by the deputy inspector of school. Then how come he can be regularized in a post of Dorong district in a non-BTC area when the petitioner was supposed to be in a BTC area? Still going on this process in the education department.
That instruction.
What instruction? Just from reading of the annexes is sufficient.
My lord.
Communication came from Deputy Inspector of Schools Udalguri, and Udalguri is in the BTC. The judgment have been reflected at para 7. You have regularized in the non-BTC area.
Initial appointment also Udalguri, man.
Udalguri. Then how come you have adjusted him in the BTC, non-BTC area? rightly, wrongly, whatever. This thing you cannot consider.
I have kindly come to page 26, annexure D, my lord. I think is this is the certificate issued by the SCRT, my lord. He completed
That is only a study center.
BTC Dolgaon, Dorong, my
Doesn't
lord.
matter, that is the study center. Only for the purpose of DLED. Not necessarily that he should be in the BTC, or he may be for that particular degree, he may be that particular course, diploma course, he can be anywhere. Nearest to his place, that's all. Third, Mr. Zailovsky, counsel appearing for the petitioner. And Mr. B. Talukdar, Learned Study Council, Department of School Education, for the respondent number 1 to 5.
1, 2, 3, 5.
1, 2, 3, and not 5. You are the finance. Are you representing finance?
No, no, my lord. 4, 5.
What's your
No,
good
no,
name?
4, 4, 4. Sorry.
What? Any standing council BTC here? Dolgaon is in Dorong or in BTC? Will be 4, 1 to 4 and 5. 5 may have number. Mr. Talukdar prays for some time to file an affidavit in this matter. While going through the annexes appended thereto in this petition, it is seen that the petitioner was initially appointed as a OBB within bracket 7066 teachers in a fixed pay. In Borongabari, BARONGABR, Dokin Suba Lower Primary School, Jongalpara, Eden District, Dorong, now in the Utalguri, in the BTC, by an order dated 13/03/2001. However, from the order dated 05/10/2016 of the Director of Education Assam, it is seen that the petitioner was subsequently adjusted in a non-BTC lower primary school, namely Khas Borkola Lower Primary School, against a resultant vacancy due to retirement of one Jitendranath Deka under the District Elementary Education Officer, Dorong. The order dated 5/10/2016 of adjustment of the petitioner also reflects that it has the approval of the Finance Department of the state. In their affidavit to to be filed by the respondents in the education department as well as the finance department of the state shall categorically apprise the court under which provisions the respondents have adjusted the service of the petitioner who was earlier in the British area, who adjusted the service of the petitioner in a non-British area in the district of Durham, though he was serving in a British area earlier prior to his search. List of the provisions on a date to be fixed by the
May it please your lordship. I'm challenging the charge sheet in this case, your lordship. Charge sheet was filed against me under section 306 and 302 and
So, Mr.
373.
Deori Vatwari Sohan. His name has been shown.
Yes, your lordship.
Respondent name is shown.
Respondent name for me.
কি matter, huh?
এটা বলে এই বাংলাদেশে মার্ডার করে বলে এটি
Oh. 302. Chauhan is for informant.
No informant.
Nahin.
Page 14 is the FIR, your lordship. May I read?
Portion of FIR. Cash it through. Come on, yeah. What's I don't know. Evidence of minority. He also had gone and asked him, he said he is. Cannot be an eyewitness.
Yes, what is the ground for quashing of this petition?
Your Lordship, this entire case is based on the statement of the 5-year-old boy, Your Lordship, whose statement was recorded after 3 years. That is when he was 8 years old. Your Lordship may kindly peruse the statement on, that's in the records, Your Lordship, because I had not.
What happened initially? That is why I was going to the case there.
Yes, sir.
During the case there, he was almost closed, but the new IO found that the statement of the husband of the deceased, statement of the informant was not recorded.
Yes, sir.
So, and the sketch map was not there. So before closing the case, because it was found that the apparel of the deceased was sent to the FSL and spermatozoa was found. So section 376 was incorporated with the approval. The police tried to have the DNA test of the petitioner.
Could not be done because fragmented.
And then after the police investigating, new investigating, when he went to record the statement of the husband of the deceased, father-in-law of the deceased, this thing cropped up.
That young boys.
Young boy informed
Acha.
grandfather, mother, that he was threatened, not directed to leave the field by the accused.
True, Your Lordship.
Right. And the father-in-law also clarified certain materials. Thereafter, the statement of the child was recorded.
Yes, sir.
So that is the reason why it is after 3 years.
Yes, sir.
Right. Investigation is like that only what to say, but it was how it has been, it is very much in detail. Just now. And in fact, at one stage, the Deputy Superintendent of Police have also written a report. But at that stage also the statement of the informant, the statement of the husband of the deceased was not there. And very interestingly, the accused himself stated that he used to knew this lady because he used to reside earlier in front of their house at Udalguri. The SP report is very interesting part is that a person concerned is involved. Some of the witnesses are there, whose wife is supposed to belong to a particular tribe of Koroyan. And this particular petitioner's wife belongs to that tribe. Everything is there. So
So it's not a case of eyewitness. It has to be established through
the
circumstances.
has to prosecution has to prove on that. But these materials, how it has propped up, not under 480. Heard Mr. T. Duty Consulate and MS as the honor additional to the prosecution. That is the record. Not the working. There is the record. Let us go to on. Oh. Zero 2/12/2020.
Deeply obliged.
Lordship has closed the matter.
Deeply obliged.
All matters we cannot enter into 482.
Lordship. Yes, Elena.
Lordship, on the last occasion, Lordship has heard the matter of that land stop. The present petition is filed by the petitioner is the police sub-inspector, Lordship. He has been implicated in a STR proceeding, Lordship, that is pending before the additional chief judicial magistrate, Karimganj, Lordship. Annex 3 is the complaint, Lordship, that has been lodged by the complainant.
Yes,
The basic contention of the petitioner is that, Lordship, the governments made in the complaint itself, as well as the deposition that has been recorded before the additional judicial magistrate, is distinct and different, Lordship. The first main contention of the petitioner. Second, it was a public mob, Lordship, where the
you said you relied on some decision. What is that?
that is 2006, 186,557, Lordship. In the case of Rakesh Kumar Mishra versus State of Bihar. Lordship may come to paragraph 6.
Yeah, this file back. Not the victim. Benefits of completion of the law. What is the benefit?
Yes, Ms. Zahan.
Not sure. In fact, it is too late in a day. So many witnesses were also examined. The complaint was of the year 2016. then cognizance taken, charge framed,
Sanction obtained or not?
Lordship.
Sanction obtained or not?
Uh, sanction perhaps will not be required in such case. It is not in discharge of the
No,
official
what
duty.
happened, what is the indication was that there was a mob. The victim was involved in certain POCSO matter. Yes.
That is a separate issue, will not affect
So
this present case.
only to, when the people, the mob
Hmm.
were against this particular person,
Hmm.
victim, he was brought to the police station.
Hmm. Police was informed they reached, but then they also started beating, including the petitioner.
That's what I say. But what is the report?
Lordship is talking of the charge sheet.
Hmm.
Charge sheet Lugona niye? Oh, complaint case. This is the complaint case. Mhm. It will be a valid case. Not a. সেটা মানে পুরোনো কেসে মাথা চেক দেবে। This is all. Independent witness of ceremony myself. PW 4, 3, Nikhil, 2, then 3, 3. 3 or 4, sir.
Please come to page number 59.
Lordship,
59.
59. Lordship. This is cross-examination.
Exactly. Kindly read.
The place of occurrence is PWD road. The said road is the unique which runs from so and so. The distance between the school and the school is so and so, the Bajishera so and so. The inhabitants of that locality consist of 80% Manipuri community and rest are Bengalis and garden people. There are 60-70 people, families reading in between the two schools, so and so, leading Moniwal, Goala and some Roy leading person are also residing. The resident of Goala ex-MLA is on the other side. The market day of so-and-so sits twice a week in Monday and Thursday. The market day starts from 2 p.m. The people of the villages so-and-so also gathered. I know that accused Sarbajit, Viswajit, Ajay, Dilip, Anshuman, Rajkumar, the petitioner, and Nihar Dev are government servants. The other accused are the members of the independent families. 4-5 days back of the alleged occurrence, I came at leave from my service. At that time, I have been serving in Jammu Kashmir. Apart from that visit, and about 4 months ago, I also visited my native house on leave and stayed for 1 month. It was the first incident of my arrest made by the police on the day of occurrence. This may not be correct. The said case is not pending before learned court of session judge. IS Sessions case. In that case, there was allegation of attempt of kidnapping and minor girl lodged against me. 60-70 people who chased me are the resident of Bajichera. This will not include the petitioner. I do not know Ajanta Lal and Halam. On 16/6 or 76, I came to visit my native house after taking leave. It is not a fact. I deposed falsely about the time of my coming to my native house. It is not a fact. I know Halam, who is undergoing training of nurse at Mukunda Hospital and used to disturb her on the way. Not a fact that Halam was residing at a tenant. It is not a fact. In spite of requests by Halam and Ananta Roy, I continued the disturbance and the FIR is lodged against me. It is not a fact I had assaulted son of Anant Lal for the said reason and also registered. On 10/6, in between me and Ajanta Lal and others, there were some documents for settlement of disputes. The local people restrained me and informed the police on the day of occurrence. Later on, police arrived, but the people assaulted me and took me towards arrival
Police
of police.
station.
Yes,
Before arrival of police.
before arrival of police. It is not a fact. Local people restrained me and informed the police on the day of occurrence. Later on, the police arrived, but the people assaulted me and took me towards police station before arrival of police. It is not a fact that accused of this neither restraint, but there is one there is one independent witness, Lordship will see PW3. He said that he had seen the police assaulting the victim. Page 61. Lordship will see fourth paragraph at page 61. Thereafter, I noticed that somehow the police of Bajichera picked up the victim from the clutches of the accused person, and in the police campus of Bajichera police, the OC assaulted the victim, but this is in the police station campus with lathi. An accused Nihar Ranjan kicked on the back of the victim. This PS campus. Kept in the local cross-examination of police campus. Hmm. There is a discrepancy. E0 process, E2 process है you know, PW4 है. Rajkumar also assaulted me in the police station.
Is a relative of the victim.
Hmm. Mhm. Hmm. Hmm. It is, so someone लिखे थे. मैं ये तो you कैसे PS. as if it মানে public justice হয়। No? কোনটা দেখাচ্ছে? সেখানে justice করবো না তো
Come to page 65, last part,
Hello.
the informant.
Yes, I have just read last. It is not a fact that my son used to ill-treat the girls of the locality. On that day, he was ill-treated. He ill-treated Ratna Paul, and the people present in a market intervened and chased him and handed over to the police. Now, it seems the factors like this, there was a mob attack on the victim. Thereafter, police was informed, police came, but the mob, they had taken down from the police's vehicle, taken down the victim from the police's vehicle, then they took him to the police station. In the police station, the petitioner had beaten him up. This is what it is seen. With a lathi, with his lathi.
What is the medical report you have? Mr. Bora?
Injury report. नहीं, हिंदू कैसा लिखना है इधर? Young long ago, that is thing. They are witness number 9 and 10 in the complaint petition. If you complaint or witness, you can. Yes, record second.
Call for the records of.
Records are on it.
Examined yet, but they are not yet examined.
No, there will be injury report in police diary, no?
Because they are only PW, up to 4 PW were examined.
Look into it. Call for the records of. Scan copy of the. Scan legible copy of CRTS number 465/2016. From the records of. From the court of London, additional chief judicial magistrate Karimganj. List on. 23rd. Copy of disorder we children, the interim order passed earlier on 13/12/2023 shall remain in public. In support of its Mr. Bora relied on a decision of the Honorable Supreme Court in the case of reported in the case of Rakesh Kumar Mishra versus State of Bihar. Reported in the case of reported in 2006 1 SCC 557. Whereas Mr. A. Ahmed Lanet counsel for the respondent number 2 relied on a decision of this court, coordinate bench of this court in the case of Abdul Karim versus State of Assam and another in criminal petition number 421/2022 decided on 16/5/2002. Okay. Copy to Google.
Please, Lords. My lords, I am a woman. I'm 50 years old. I have been arrested on the 25th of May, 2021, my lords. Since then, I'm in prolonged incarceration. So that means 3 years, 3 months, and 8 days. My lords, I was arrested for an NDPS case. In all candor, my lords, the first section against me is section 20, commercial. The other section is section 21, intermediate. And the last section is 29, consumption. Because I have been, it is allegedly recovered from me 28.455 kilograms of cannabis and 10.54 grams of heroin. Lords, the first bail application was listed on the 27th of June last year, which was disposed of by my Lord's bench. And therefore, I am before my Lords in this instance, second bail application for hearing. My Lords, the facts are prevalent. My Lords, the first bail application order on the 27th of June 2023 is available at page 38 in my bail application. From page 38 to page number 41. Briefly, my Lords, my first bail application was rejected because of prima facie material on record. Now, my Lords, it has been about 3 years, 3 months, 8 days precisely. My ground is only single. I'm praying release enlargement on bail on the ground of undue delay, my Lords. My Lords may have the law, the NDPS Act, Section 37. That is the rigor that prevented me from grant of bail. Yes, Section 37. My Lords, have it, Section 37. My Lords, under subsection 1(b), no person accused of an offense punishable with offenses, my offenses, shall be released on bail or on his own bond unless the learned public prosecutor has been given an opportunity, and where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds of believing that he is not guilty of such an offense and that he is not likely to commit any offense while on bail. My Lords, am I audible?
Yes, yes, very much.
My Lords, this learned PP will be heard in the instant case. My Lords, this condition, I would like to bring your attention, my Lords, to page number 47 in my bail application. This is the case of my Lords, the Apex Court in Ravi Prakash versus the state of Orissa. My Lords, para 4. My Lords, I'll read. My Lords, may I read the 4th paragraph? So, my Lords, this is again referring to Section 37, which I read just now. As regard to the twin conditions contained in Section 37 of the NDPS Act, learned counsel for the respondent state has been duly heard. Thus, the first condition stands complied with. So far as the second condition, regarding the formation of opinion as to whether there are reasonable grounds to believe that the petitioner is not guilty, the same may not be formed at this stage. At this stage, my Lord, when he has already spent more than 3.5 years in custody. This was with regards to a commercial quantity of cannabis. The Lord knows about the Muhammad Muslim case, which was passed on in 2023.
Yes.
To support my contention, my Lords, there has also been a matter under prevention of, under UAPA, my Lords, where the same ratio of Ravi Prakash and Muhammad Muslim was relied on to grant bail to accused under special acts. My Lords may have page number 80 of my bail application. Because this is the matter of Javed Ghulam Nabi Sheikh versus state of Maharashtra. This was passed right before I filed this bail application, my Lords. In this case, a boy was arrested for possessing allegedly counterfeit amounts of currency. My Lords, have page 80, para 19. I'll read, my Lords. May I read with para 19, my lords? Number 19, if the state or any prosecuting agency, including the court concerned, has any wherewithal to provide or protect the fundamental right of an accused to have a speedy trial as enshrined under Article 21 of the Constitution, then the state or any other prosecuting agency should not oppose the plea on bail on the ground that the crime committed is serious. Article 21 of the Constitution applies irrespective of the nature of the crime. At this juncture, my lords, I would like to recall what Srimati Pushpa Kapila Hingorani did when she filed the case for release of the under trial prisoners in Patna in Bihar, Muzaffarnagar in Bihar. In the similar 1979 judgment of Husainera Khatun versus State of Bihar. My lords, there Justice P.N. Bhagwati took cognizance of the offense in the nature of a class action lawsuit, the first PIL in India. The first PIL in India, my lords, is on the basis that the right to speedy trial is a right to life and liberty, is an expanded scope under Article 21.
What was the recovery from you? What was the recovery from you?
My lords, my alleged recovery is 28 kilograms and 544, 28 kilograms, 0.544 milliliters of cannabis. I'm jumbling up, Lord. Yes, Lords, 28.455 kilograms of cannabis and 10.24 grams of heroin. That is intermediate quantity, Lord.
Taken into custody on
25th of May 2021, Lords. $1,196 minutes. At the juncture, Lords, I pray that I may be released on bail. So much time has passed, my lords. Only 6 witnesses have been deposed out of 21. There are 12 accused in this case. All of them have been granted bail except me and the other co-accused. Interestingly, my lords, even when I was charged by the trial court on the 18th of August 2022, my lords, there was another accused. There were 3 accused in total. Out of those 3, 1 has been granted bail.
Yep.
I may submit, my lords. May I submit, my lords?
Just a minute, just.
Please.
Yes.
Lords, page 10. Lords, at page 10, para O. One of the grounds for considering my prayer, my lords. This is a compilation of all the judgments of the Supreme Court wherein the apex court has granted liberty of bail to the applicants. Ravi Prakash versus State of Orissa, my lords. Behind bars for 3 years, 6 months, under 20 cannabis commercial for 247 kilograms, my lords. Next, on the next paragraph, my lords have it. My lords have the next motion. Para B, in Chitta Biswas versus State of West Bengal, behind bars for 1 year, 6 months, under 21, a manufactured commercial quantity. Here I am intermediate. Here I am intermediate, my lords. Sure. Nitesh Adhikari, see, it goes on and on, my lords, versus the State of West Bengal. Behind bars for 1 year, 7 months, under 21C, in commercial quantity, manufactured drugs. 4.80 liters of suspected codeine. The list goes on and on, my lords. And at page 15, my lords. At page 15, my lords.
Yes.
Lords, para P. These are the judgments by this coordinate bench of this Honorable High Court, my lords, wherein the liberty of bail has been granted to accused applicants for under the NDPS Act. Similarly situated. All of them similarly situated. Therefore, my lords, I pray that it is high time that the applicant be charged on bail on the ground of undue delay. I conclude my submissions, my lords.
6 witnesses examined.
Yes, my lords. Out of them, only one witness is my punch witness. My lords. There is only one. And he has stated very categorically that he has not seen any drugs.
Yes, Mr. Busso.
My lord.
All these judgments for
Yes,
release
my
of
lord.
bail.
On the part of
Coordinate
following
bench
intersection.
passed various orders. What do you have to?
My lord, earlier rejected on 27/6/2023 by this honorable court, my lord. At that point of time, my lord, 4 numbers of witnesses are examined. And this trial started, my lord, on this 1/9/2022. Charges were framed, my lord. And my lord, then thereafter, my lord, only 6 numbers of witness are examined. That is on 26/6/2024, my lord. That is in the part because the PWs are absent in many
From
days.
31st of May 2023 to
Yes,
today,
my
we are
lord.
in 2nd of September.
Yes, my lord.
Only 2 witnesses have been examined.
My lord, because on 31st of May 2023, PW3 and PW4 was examined. Then thereafter 28/6/2023 was the date fixed. PW is absent. 26/7/2023 PW.
The prosecution fails to place the witnesses.
My
what will
lord.
be the consequence?
My lord. That part is there, my lord. But other than that, my lord, when rejecting the earlier prayer, my lord has already stated that is the regarding the involvement and the materials against the person. I haven't gone through that.
But the search sheet, how many witnesses to
21.
Okay. Anything else, Mr. Busso?
My lord, there is a Dove, it is, she was arrested on, my lord, 25/5/2021. But my lord, trial started on 18/8/2022 because all are not present that time and the charges were framed on 18/8/2022. And then thereafter also another one date for 1/9/2022. So my lord, the evidence will start from 23/9/2022. But my lord, it is a admitted fact that during when it was rejected, there is the 4 numbers of witnesses has already been examined.
Out of those 4, my lord, if I may.
And only one date was there that PW is present, my lord, but he cannot be examined. Only one date was there. Other than that, my lord, only 2. But my lord, in this regard, already, my lord has already recorded in earlier order. That is how the nexus is going on in those localities and involvement, and from the conscious position itself, the contrabands were recovered, my lord.
Less than 9 for now. Okay, 46.
Below, I have a small submission below. The 9th, I have another matter, my lord.
Ask someone to be here. We'll just pass the order on.
Obliged, my lord.
Item number 46, Lordship, have taken out those judgments on consent of the minor, although they cannot be under question under POCSO or under IPC, but still courts have gone into this aspect and have acquitted, enlarged on bail, quashed by giving regions, by giving appropriate directions to the law commission. So many, but I would like to place 5 judgments mainly. That first judgment, this is Ashik Ranjan Ansari versus State of Maharashtra. It is Bombay High Court. Lordship has High Court software in your Lordship's computer. Lordship can take it out. Citation is crimes. I have the citation from crimes. This is Ashik Ranjan Ansari versus State of Maharashtra.
Do one thing.
I'll give a list.
You give the list and the citation.
Type out,
and take it out.
Yes.
Okay.
Lordship. I'll just point out the facts and what the court did. Here, Ashik Ranjan Ansari, what happened? The victim was of 17 years, 5 months. But mostly these cases are from age 16 to 18, not beyond, below that. And where consensuous thing is there was a relationship and the girl had herself gone with the victim or with the accused, or she was agreeable to that. So in those facts, these cases are dealt with. In the first case, Ashik Ranjan, what happened? The appellant was convicted for 10 years under POCSO. Girl was 17 years, 5 months. And the offenses were of 306, POCSO, everything. And the fact of the case is brother of the victim, he lodged the Ejahar saying that the sister went out to purchase something and then she was missing. In fact, they were also not in the house. The brother of the victim, they had gone to attend their grandmother's ceremony. Wife, his sister and all.
The citation to look into it.
Lordship.
Pass the order on 10th.
No.
Now this,
You have to rise because of.
No, we understand, ma'am.
there are
Yes,
so many
Mr. Ram.
facts.
You give us that list.
Court will look for that.
Lordship.
Because this is only a fail application, I believe.
Yes.
During the, because appeal has already been admitted.
Yes, Your Lordship.
What do you have to say?
Your Lordship, I do differ from our learned PP because here it was not that the victim, she has nowhere said that she had agreed. She just has said that she was in a relationship, but she has not agreed to anything further. And she has been consistent in her statement before the police as well as the magistrate. Though there's nothing about consensual does not stand here,
No,
but also
no,
even
don't
that.
just take two things. One is
Yes, Your
that
Lordship.
we are here for the pay.
Yes, Your Lordship.
Because appeal has been admitted. We are not in the appeal.
Yes, Your Lordship.
In that
Not on the
background, you
merit.
can tell us.
Yes, Your Lordship. So, Your Lordship, I will leave it up to Your Lordship's discretion But however, if we go on lines of what our learned PP is saying, I do differ.
Those are, I think, the
with that.
final orders acquitting the accused.
Those are all final orders.
Yes, Your Lordship.
One is bail, one quashed.
What?
One appeal is, he is acquitted on these grounds. But then, yes, she is right in saying that there the girl agreed on the relationship.
In our case, only the boy was just blowing the motorcycle gear and she came in.
This is somewhat
There's no
similar in nature.
enticing of it. 363 will never come into it, madam.
However, Your Lordship, we consider also the length of incarceration. It's just 10 months that the boy has been in
Jail.
jail. Your Lordship may take that up.
In fact, one of the decision there, the boy is said to have induced the girl and took her when she went to purchase something from the shop. And then in paragraph 27, it is said that POXO is little problematic and the person is acquitted. Because society has to, Lordship has to see what is going on in the society. One cannot be again put inside bars for such acts, which is very common in the young age and all. Here the appellants are also quite young and all, 20, 25, 27.
20,
Here also, I
17.
think
20
the
and
boy
17.
is young,
Boy is 20 and girl is 17.
17. So many paragraphs, in fact, High Court has dealt with, I mean, had stated. Law Commission report also, I have mailed it, Lordship can see.
Look into it.
Law Commission report.
I said corrected, madam. At the time of occurrence, the boy was 17, 18 years, 4 months.
You have seen that.
Yes, madam. That is what I'm putting. And the girl was 17 plus.
16 years.
Around 17.
I think these judgments will cover because both are young and
Only
then.
thing is that the victim stated that the boy was honking from the outside in his bike and threatened her that if she doesn't come out, he'll go to
He will go inside or.
So that's how the girl has narrated the fact. And you look into it.
But one aspect, 363 kidnapping, madam, there must be enticing so as to follow him or pick up, madam. Otherwise, just mere threatening is the reverse one, madam. If you don't come with me, I will come inside, madam. Then that way she came to the motorcycle, madam. At the
Few
place where
facts
the
are-
occurrence took place regarding the real incident, madam, that is also not being supported by any evidence.
So what
Rather, there's a
is,
reverse
one
evidence on
statement
that
of the
aspect.
victim is that
Yes,
she
ma'am.
doesn't know the place
Yes.
in which the occurrence
Yes.
occurred because she said she
That
didn't see that.
witness has
But
also
some
not
other lady
supported.
has been brought out, but is not the that particular lady when it's made a witness, though made a witness.
Right.
We found from the records that it is not the girl, the victim, led the police to that particular place of occurrence.
How?
Somehow,
Yes.
police of their own have done it. But
No,
it
I
is
think the
not
girl has identified it. During investigation, the girl has shown it, madam, because that's why the police could go there.
Go to the record.
Yeah, Lordship will look into it, madam. 161
only
copy is
in,
that way.
bail
Police will
during
put the
dependency of the
charges,
appeal.
police in the
That's
court.
what it does.
Yes, yes, Your
We'll
Lordship.
look into it.
We leave it to the Lordship, madam. Only she will furnish the copy, madam.
I'll give the list of
Yes.
books tomorrow, Lordship.
We'll look into it.
Along with the judgments I'll give because it's difficult to find sometimes High Court judgments.
Okay.
But
Just,
Manavatra and
you
Supreme
just,
Court is available.
just
Mail it,
mail it. We'll take
mail it. I'll mail all the judgments.
That's good.
We'll rise for the day today. We have some.
Much obliged.
Obliged.